I'm Rose Webb, and I'm chair of the NRCOP National Committee. I'm very pleased to be here with everyone today. This is our first attempt at a late evening or late afternoon, webinar, at least for people on the eastern seaboard of Australia. I know a lot of other attendees, it will be mid-afternoon or lunchtime. We're doing this as a bit of an experiment to see how this timeframe goes, but also particularly because we're very grateful to one of our speakers, Miguel, who's joined us from Paris, and it's early morning for him. So we're glad he got up early in the morning, but we didn't want to make him get up in the middle of the night. So we've got participants from all over Australia and I think across the world at this webinar. I'd like to begin by acknowledging the First Peoples from all our countries and pay my respect to them. We honour their wisdom and stewardship of traditional lands, waters and customs which enrich us all. Just a few general points about NRCOP webinars. Most of you will know these webinars are recorded and they'll be available on the ANZOG YouTube channel in about 14 days. We're using the Zoom platform today and the Q&A function in Zoom. And so I really encourage everyone to put any questions they have in the Q&A panel as they go through. Just click on the Q&A down the bottom of your screen and you'll be able to insert your questions there. You can also vote for other people's questions to bring them to the top. Happy for people to do questions as we go through the session today, but we do have a special time for questions at the end. And we really appreciate people making this a good interactive session. So today we're talking about Agile regulation. Many of you might have heard of Agile first in the context of project management, maybe, where there's a distinction between the traditional sort of waterfall style of projects, where people did a lot of work and delivered with a big bang at the end of a time period, and Agile methodology looks to do things in a different way, obviously a more agile way. And I think many of you will have heard of terms like sprints and minimum viable product and co-regulation, co-design, and some of those words that have been used a lot in IT projects particularly, but also in other sort of project contexts. And what we're thinking about today is how much does all of this apply to how we do our regulation, and do we have some things that we can learn from that agile methodology that will make the way we do regulation better. We're coming at it from a few different angles. The OECD have done some great work on agile regulation and Miguel will talk to us about that. Anna will talk a little bit about how particular circumstances can make a regulator have to be agile. They've got no choice. But then once you're in that situation, how do you deal with situations that might come up that you didn't expect and have forced you down the agile path? And then we have Florent who will talk a little bit more to how we can use some of these agile ideas for just traditional regulation that we do. So I'd just like to introduce each of the speakers first. We have Miguel Amaral, who's a senior policy analyst at the OECD, and as I said, coming to us from the OECD in Paris today. He heads the work on better regulation and innovation, including the OECD recommendation on agile regulatory governance to harness innovation. Before joining the OECD, Miguel was head of infrastructure management unit at the French transport regulator, and he's also served as chair of the binational permanent service for the regulation of the Channel Tunnel. Anna Brakey is a commissioner at the ACCC. She was appointed in December 2020 and also associate member of the Australian Communications and Media Authority. Anna's had over 25 years experience in a number of regulatory and government positions, as well as with the private sector, including regulating infrastructure industries such as water, energy and transport. And Florent is a well-seasoned evaluator. He headed the evaluation team in the New South Wales Better Regulation Division in recent years. And before he did that, he was an external evaluator for 10 years working at Ernst & Young in Paris before moving to Australia. And he has launched and led the evaluation community of practice at the New South Wales Department of Customer Service, and also chairs the New South Wales Committee of the Australian Evaluation Society. So we have a very well experienced, but also coming at it from different angles, team of speakers. And I'd like to first of all pass over to Miguel to give us an outline of the OECD's work in this area.
Yeah, thanks a lot, Rose, and thanks for the invitation. So to set the scene, basically, I will try to give you a quick overview of the questions that the recommendation is trying to basically address. So the first one is the pacing problem, basically the fact that kind of regulation is often lagging behind technological developments, and the problem is that the cost of regulatory failures in some cases might be potentially high. The second, next slide, please. The second issue has to do with the existing regulatory frameworks, because we know well that in a number of cases, digitalization is blurring the lines between markets, between sectors. If you think, for example, at the new conversions between media and telecom markets, it gives you a clear illustration of the fact that, digitalization is kind of blurring the lines between, traditional markets and sectors. And that's a challenge for the existing regulatory frameworks. A third challenge is in fact the enforcement challenges, which are mainly due to the difficulties to define and attribute liability as soon as AI is involved. So the problem with AI is, for example, who is liable when an AI system fails to perform? Is it the owner, the user, programmer, the developer, the software developer, etc., etc. So this is raising a lot of issues in terms of how we need to enforce existing regulation. Last but not least, there is institutional and transboundary challenges. Why? Because digital technologies does not respect the different layers of the governance, and then can span multiple regulatory regimes, for sure. And also digitalization pays no regard to national boundaries. So it might enable companies to form shop when it comes to their physical location, to their tax policy, to their policy in terms of data protection, and it may also raise some potential barriers to the spread of beneficial innovation. Next slide, please. So the key idea of the recommendation is to help policymakers rethink their approach to regulation. And the recommendation is basically organized around four main pillars. So next slide. The first is on the need to adjust regulatory management practices. The idea is to really develop more interactive and flexible regulatory management practices, building on constant monitoring and ex post evaluation, to providing more flexibility in regulatory impact assessment approaches, in close combination with the result of ex post review. And the recommendation is also putting forward the need for more nimble, more agile approaches to stakeholder engagement, and that's really key. The second pillar is on the need to foster cooperation and joint-up approaches, including across jurisdictions. As I told you, innovation is really cutting across administrative boundaries. So there's really a need to foster cooperation within the government and try as much as possible to develop whole of government approaches to regulations. That's really essential for a number of technologies, the digital ones, but also non-digital technologies that are also somehow, cutting across the different, the organization of the different ministries, basically. And second, under that same pillar, we are also putting forward the need to step up international regulatory cooperation, given the massive transboundary challenges of innovation. So the recommendation is really insisting on the need to make the most of the bilateral, regional, or multilateral approaches to cooperation, really to first foster mutual learning across countries. Second, to improve coherence across the different regulatory regimes. And third, also to develop well-relevant, this is not always the objective to fully align regulatory frameworks. We can have a word on that during the discussion, but basically try, when this is relevant, to develop joint-up approaches to regulation. So clearly, the international regulatory cooperation within the recommendation is really a key transversal message. The third pillar is around, the need to develop more agile approaches to regulation. So the recommendation is putting forward the need to create some space for experimentation via regulatory sandboxes, really to foster policy learning and adaptation as the technology is developing, basically. Second, under that same pillar, the recommendation is insisting on the need for governments basically to anticipate much more by means of horizon scanning, scenario planning, and also a much more active engagement with stakeholders, including the business community. We do think that business might indeed be aware well before government of what is going on in markets and what are the risks and the opportunities raised by a specific technological development. So engaging with businesses, big tech, but also SMEs is absolutely key going forward to implement the recommendation. Third, under that third pillar on the agile approaches, the recommendation is insisting on the need to really kind of better harness all the opportunities provided by soft law approaches. So this is, for example, self-regulation or co-regulation with the industry, but also the development of industry standard. It could be really a relevant complement to more, let's say, traditional approaches to regulation, providing a bit of agility, in particular at the early stage of the technological developments. And last but not least, under that pillar on agile approaches to regulation, the recommendation is, putting forward the need to better harness all the opportunities provided by outcome-focused approaches, not systematically relying on rules-based regime to address the challenges of innovation. So this is really, we feel like this is really good in terms of, providing incentives for businesses to develop to develop innovation, basically in a kind of cost effective way. So we do feel like there is really a need to harness this outcome-based approaches to regulation and extend by the same way, the regulatory toolbox of regulators. So that's for the third pillar, the need to develop more agile and nimble approaches to regulation where possible, when relevant, of course. The last pillar, and I would like to insist a little bit on this because given the data we have on regulatory management practices across countries, we know that regulatory delivery is not necessarily the most loved practices in comparison to regulatory design, and basically, so there might be a gap here in a number of OECD countries as regard the policy cycle. So the recommendation is really has made this as a strong pillar indeed, and is kind of promoting two main ideas. One is to move towards more agile approaches to enforcement, meaning that there is a need to promote outcome-focused and risk-based approaches to regulation, not strictly relying on the precise contents of the law, but trying to find another way to think about enforcement based on a proper risk assessment, basically. And also, we do feel that there is really huge opportunities provided by digital technology. So clearly, digital technologies are bringing a lot of challenges in terms of better regulation and regulatory policy for governments. But at the same time, they could really help government overcome some of those challenges, basically. And one key promising avenues to really harness those opportunities is on the enforcement side. You can really use data, big data, AI, IoT, if you want, really to improve the monitoring of activities, basically, to improve, you know, the enforcement of regulation on almost a continuous basis. So we do feel like, and there is a number of promising examples across countries, but we do feel that this is really a promising area that should be fully considered. So just a couple of remarks to conclude. I guess we will circulate the slides, and you're going to find an annex in the slide providing some details on each of the different 4 pillars, but I won't have time to go through it in detail. But just a couple of remarks on this. First, we've tried to make as clear as possible that none of these so-called agile approaches is without limitation or without flaws. Basically, we do feel that self-regulation will only work, for example, when the interests of the state, of the government, and the interests of the industry are aligned to a certain degree. If not, well, the option of self-regulation must be carefully considered. Same for the outcome-based regulation. It might raise a number of uncertainties for small businesses to understand how to comply with, you know, this outcome-based regime. So might be a need also to combine outcome-based regulation with some form of regulatory guidance to provide additional certainty to businesses on how to, you know, to meet the regulatory objective. Might be quite easy for big tech firm, for small companies, not necessarily. Same for regulatory sandboxes. It might raise some competitive concern. This is well known. This is well documented in the literature on the topic. So, might be also a need to carefully consider what could be the adverse effect of choosing, you know, regulatory sandboxes in terms of competition. So that's for my first comments. Second, the recommendation is also insisting on the fact that all of these different approaches need to be implemented in a dynamic perspective. We do feel like there is kind of a need to get away from that strong idea, basically, that you know, regulation is static by nature. So we do feel that there is kind of a need to rethink and to change the paradigm in that perspective, and maybe think really to implement this, you know, the range of different available regulatory approaches to governments in a more dynamic perspective. An example, it could be super relevant at the early stage of the technological development process to start with regulatory sandboxes, just to, again, to foster policy learning, to understand the technology, to get a better sense of what are the risks and opportunities, and to let also the technology develop, basically. So that's for sure. But as soon as the technology is becoming more mature, you know, then there might be a need to move towards other form of regulatory or non-regulatory approaches. But, you know, thinking about the regulatory sandboxes is also means thinking, you know, in a dynamic way and trying to think about the middle long-term regulatory solution, and regulatory sandbox can really help in this regard. So that's not for sure the magical solution to every single technological developments. And last but not least, I'd like to insist on the fact that you're going to find in the recommendation a list of some key preconditions for the proper implementation of the recommendation. One is to build appropriate capacity within governments, simply to understand, you know, the regulatory gaps, the regulatory overlaps, the regulatory uncertainties for certain technological developments. Second, to design the appropriate regulatory or not regulatory regime. The regulatory response is not necessarily the best course of action, basically. You know, there is no need, absolutely no need to rush into regulation, of course. And third, develop capacity to enforce regulation, building, you know, on the opportunities provided by digital technologies. And fourth, to monitor on a continuous basis existing regulations. So coming back to the first pillar of the recommendation, saying that there might be a need to reorder, you know, the way we think about regulatory management tools. Most governments start with a proper regulatory impact assessment without any knowledge about what is existing regulatory frameworks, on whether the existing regulation raises issues or not. So we are almost saying that a good way forward would be to start with the ex-post reviews and a proper evaluation of what is going on with the existing regulatory regime, and building on that information starts to inform a regulatory impact assessment. So, but in order to do that, you need also to build capacity in some cases for government. So in that perspective, there might be two main levers. One is, of course, to reskill the workforce when possible, when needed, when relevant, of course, but that's also a key precondition also for the proper implementation of the recommendation. And second, we do feel that all of the challenges raised by innovation, they do also raise the need to rethink, in some case, the governance frameworks and adapt where relevant, where necessary, the mandates and powers of regulatory agencies. That's it for me in a nutshell. So I hope you get a better sense of what is laid down in the recommendation, and happy to take any question during the Q&A.
Great. Thanks, Miguel. You certainly raised a number of really interesting issues and challenges there. And I'll just remind people that you can also look on the OECD website and see a lot of detail about the recommendation there as well. And we'll have some questions, I'm sure, from Miguel later. But we might move on to Anna to just hear about how the ACCC became agile and dealt with some immediate problems, I think, with some of the solutions that maybe Miguel had mentioned as well. Thanks, Anna.
Thanks, Rose. Look, I'm going to talk about what happened in practice at the ACCC in response to COVID-19 and how the ACCC did need to adjust some of its practices. So in general, competition provides economic well-being and the interests of consumers. Businesses competing to win and retain customers by offering better products at lower prices is necessary for the efficient functioning of markets and to increase economic prosperity. So formal or informal agreements between competitors that substitute cooperation for competition usually undermine those benefits. And competition law, which the ACCC enforces, is designed to ensure that that doesn't occur. However, in some circumstances where cooperation among competitors can promote the public interest, there is a statutory process called authorisations through which firms can proactively seek the ACCC's approval and immunity from prosecution for what would otherwise be a breach of the competition law. So the statutory timeframe for the ACCC to make a decision on an authorisation application is 6 months. However, the ACCC has the ability to grant an interim authorisation during those 6 months ahead of making that final determination. The ACCC can grant the interim authorisation when it considers it is appropriate to do so, and that's a different test to the net public benefit test required on an authorisation. The ACCC applies a range of factors in determining this question, including the urgency of the conduct, the potential harm to the applicant and others, and whether the interim authorisation would result in irreversible changes to the market pending the ACCC's final decision on the authorisation. So COVID came along in 2020 and Australia's authorisation regime proved to be flexible and resilient in the face of the challenges thrown up by the pandemic. We received around a year's worth of applications in about 6 weeks across key sectors of the economy, covering things like the supply of medical equipment and availability of hospital capacity, financial hardship for customers and businesses, and as everybody probably would have experienced, supply chain issues, for example, supermarkets, fuel, some infrastructure and essential services. So the rapid onset of the economic challenges caused by the pandemic, the size of the challenges and the time critical nature of the responses created exceptions to the usual economic rules. So every COVID-19 related authorisation application that we received included a request for an urgent interim authorisation. In many senses, it was the interim authorisations that were the critical decision point for the ACCC in relation to these applications. Our standard target is to make a decision on an interim application within 28 days if the request is urgent. But in the context of the immediate disruption being caused by the pandemic, that timeframe was just too long. So through rapid adjustments internally to processes and to analysis, in most cases, the ACCC was able to achieve turnaround times between a few hours and a few days. The ACCC responded quickly to inquiries about interim authorisation and proactively engaged in informal discussions with applicants before they applied for authorisation. And that was really key to sort of getting the right information and being able to make those decisions quickly. In order to achieve these outcomes, the ACCC redirected substantial resources and focus to the COVID-19 authorisation applications. Non-urgent work was deprioritised. And with so many businesses and government agencies at the time, the project teams worked very, very hard, very long hours. And experts across the agency contributed their insights in various industries such as telecommunications, energy, small business and fuel. The ACCC rearranged its internal scheduling so that commissioners could hold meetings. The commission meeting is usually weekly, multiple times a week, enabling us to make decisions on the interim authorisations rapidly. Now, that might sound relatively easy, you know, you've got the commissioners and they just needed to meet more regularly, but just to provide a little bit of context around that, there are 7 commissioners, but each week there are 14 decision-making meetings at the ACCC through the committee structure and the commission meeting itself. So basically the commissioners' diaries are set at the beginning of the year, and it is actually quite difficult to rearrange meetings, but nevertheless, they were rearranged and it allowed for that rapid response. But the ACCC did take a risk-based approach. We granted interim authorisations that were broader in scope than what we would normally grant, recognising that the businesses were unable to predict with certainty precisely the types of collaboration that they would need. The ACCC did so without the breadth of consultation that it would normally undertake, since there was a strong justification for most of the authorisation applications and a genuine need to respond as quickly as possible. The ACCC ensured that the fundamental purpose of the conduct authorised was legitimately linked to a public need arising from the pandemic, and that the bounds of the conduct served that purpose. Generally, the conduct authorised was in direct response to the effects of the pandemic, addressed an existing or realistic future need, particularly of patients or consumers, and particularly relating to the essential goods and services, and would also be more efficient or quicker in addressing this need than a unilateral action or a government action. The ACCC excluded conduct that would clearly not be merited, such as price fixing. The price for goods and services is the most visible field of rivalry between competitors and was not something that businesses needed to agree on to overcome the challenges of the pandemic. At a time when many were facing financial hardship, price competition was more important than ever. Importantly, the ACCC retained the ability to revoke or replace interim authorisations at any time if needed, and this provided additional comfort in granting those broader authorisations. To complement this ability, the ACCC imposed stringent monitoring and reporting obligations on the applicants so that it would be aware of emerging issues or problems with the conduct as it was implemented. So that is a bit of a really quick run through what happened in relation when COVID hit. But it's safe to say that those sorts of authorisations have continued to come up, both in relation to COVID, but other events subsequently, like the floods in South Australia that cut the rail from the east coast to the west coast. So that was they have proved to be useful on an enduring basis. The other completely different thing that I did want to talk about was our regulation of the NBN. So the NBN is our national broadband network. It has a regulatory framework that we think needs revising. So in the middle of last year, between lockdowns, we decided to kick off a process where we would talk to stakeholders about what that regulatory framework needed to look like. We thought, you know, in any situation, we try to have a consultation process that is fit for purpose. So I always think that you need to have regard to what you're trying to get out of it, what stakeholders are trying to get out of it, and then design the consultation around what's going to best achieve those outcomes. So we did that, and we felt that what would be best would be a face-to-face meeting of all the stakeholders where we got in a room together and actually thrashed out the issues. And we did feel that face-to-face aspect was going to be quite important. Unfortunately, the week before the roundtable, the limo driver picked up the FedEx staff and drove them back to their accommodation, and so the Delta outbreak started in Sydney. So, you know, we did stop to think, well, what do we do here? I think other states were concerned if they came to Sydney. People from other states were concerned if they came to Sydney, they would not be allowed back into their own states. And so we did have to stop and think, well, what do we do now? And again, we asked that question: given this set of circumstances, what's going to achieve the outcome the best? And you know, this isn't a surprising story. There's nothing surprising in here at all. But what we did was we decided to do a hybrid. Where the people that could come to Sydney did come to Sydney, and it really did help to have people in the room eyeballing each other and having those conversations. But it was a hybrid where people could come in externally. So from there, we had to figure out how to consult during the remainder of the year. And I think that change really brought us into a new way of consulting, which was to run basically weekly workshops online. Everybody was online. You know, that had some real upsides. I don't think people would have been able to commit that amount of time, you know, if they had to travel to do so. So that was a real upside. I think the intensity we benefited from. But I do think that in online forums, people can more easily be quite passive, not engage, and the debate is much harder because you can't have that back and forth in the same way that you can when you're in a room having a discussion together. So where does that bring us? I mean, that's there's nothing surprising in that at all, because that's what the world was facing, right? But I think it just has given us a new range of possibilities in consultation that are now tried and tested, and that we'll keep that. But I do think that what's important is that you always have regard to what's going to suit that circumstance at that time. And I'll leave it there. Thanks, Rose.
Great. Thanks, Anna. And yeah, it is sort of interesting that a lot of the original theory of Agile was all about people being in rooms together and working very closely together. And certainly COVID's made Agile have to be Agile as well in some of those ways that you mentioned. Okay, we'll move on to Florent now, but just a reminder to everyone, if you had any questions for any of the panel members, just put them in the Q&A function and we'll get to them after we hear from Florent.
Thank you, Rose. So I will now try to provide you with a couple of practical examples of techniques and tools that are borrowed from the evaluation field, which I'm from. And it's not only you'll see about post-evaluation, it's about actually setting the scene. And we're going to be talking about outcome framing in particular. And the second aspect being also iterative assessment cycles, which are relating to two of the principles that sit under the OECD recommendations. Those techniques are not only useful to support innovation as part of the OECD recommendation for agile regulatory governance, but also it's useful in the traditional regulation space, as you will see. And they're useful in the sense that they can provide useful navigation aid. And I was just watching Malcolm Sparrow talk in this very forum in 2020. I think he used the same sailing analogy, so it's quite relevant to use those evaluation techniques. So we'll go to the first one with the next slide on lighthouse. So that refers to the principle number 7, I believe, in the OECD recommendation supporting principles, which is around developing more outcome-focused regulatory approaches. What does that mean? Outcome framing is basically a way to make sure we always keep an eye on the end game, your destination, basically the lighthouse, to make sure that you don't crash on rocks as you get sidetracked by mermaids or other winds. So what is our lighthouse in the regulatory world? These are the ultimate intended outcomes for your various target groups, for your intervention, for your regulation. Outcome framing is more and more prevalent and required as part of ongoing government accountability requirements, but also as part of internal processes, such as outcome budgeting that you may have heard about. Now, how do we develop outcome-focused regulatory approaches, and how can evaluation techniques help with that? The most common evaluation tool that you'd be probably familiar with is program logic. So program logic is a visual representation of a program theory, which is the sequence of intended outcomes for a particular intervention or regulation, or it can be for a whole organization, as you can see on this slide. It brings together the theory of change, which reflects the mechanisms that would drive behavior change, and the theory of action, which is how you trigger those mechanisms. So that's for the evaluation theory. You can see on the screen how that can look like in practice. That's for a whole organization, which is the Better Regulation Division in New South Wales government, which is quite specific in the sense that it has a mandate across different regulation areas: work health and safety, consumer protection, liquid gaming, and more recently, construction. So that the implication of that's not the only one. In New Zealand, you've got the Ministry of Business, Innovation and Employment in this case. The implication of that, though, is that when you define your outcomes, they are more at a more generic level because they are across different regulatory area. So the program logic, as you can see from top to bottom, it outlines in a diagrammatic way the problem that you're trying to address, the inputs you can rely on as an organization or through an intervention or regulation, the types of key function that you do deliver. And quite often in terms of measurement and framing, we stop there, but then it's, so what do we want to change? What do we want to do? For whom? That's the outcome section in blue. And that is supposed to be unpacked in a sequential way, which helps also unpacking some of the assumptions, implicit causal links, by communicating on new licensing requirements. We sometimes expect that by magic, the industry will become compliant. And that also helps thinking about how would you measure performance. And I'm happy to talk more about how to identify appropriate outcome indicators at the high level, because that can be quite tricky. So if we move to that's very high level, and that's for the outcome framing. If we move to the next slide, which is about a second principle in the underlying the OECD recommendation, which is about developing more adaptive, iterative, and flexible assessment cycles. This is particularly important when you develop new regulation. You don't want to wait for 2 years to know that you're completely off track, that you completely sidetracked, you don't see the lighthouse anymore. So you want to keep an eye on the lighthouse, but you want to make sure that you're on the right track based on the evidence against the short-term outcomes, which are those stepping stones, and correct your trajectory if you're not. So now talk about the introduction of a new legislation around the construction industry in New South Wales. You're probably aware, we've talked in this forum before, in New South Wales in 2020, 2021, there's been new regulation introduced around to improve the compliance of the construction industry with the Building Code of Australia. New regulation was part of a broader, new legislation was part of a broader strategy called Construct New South Wales, which relied on different strategies, including new laws, but also training and rating tools and other aspects covered under each different pillars. And as you know, introducing new legislation is not about just drafting a new laws. You also need new systems, new staff training, and new ways of communicating to your regulated industry. And you want to make sure that, as I said, you are on the right track as you go through these different steps. So let's look at the following slide, which is a practical example around how you can make sure that with this new legislation, you're on the right track to make a difference, to get towards a more compliant industry. You can see on the slide a survey of new regulated entities and their awareness of the new requirements. So when we started evaluating, so it's not ex post, it's not ex ante, it's in Latin language, in itinere, along the way, we looked at our staff and the regulated entities. Are they aware? Do they understand the new laws? And if, for instance, your staff don't understand the new legislation properly, well, that's a signal that probably you may have, well, either they need more training, but also the industry may struggle as well. And also by checking that the awareness aspect is working well, you can also, make sure that then you look at other aspects, the training or the competency rating, and then you keep an eye on your end game, the compliance game, and then you can follow your sequence of outcomes, intended sequence of outcomes, so that if it doesn't go in the right direction, then you can tick off what seems to work well and then focus on what seems to not go help you get into the right direction. This is basically an agile approach to implementing new regulation by feeding back through feedback loops and then going back to the regulation if it needs some tweaks or the systems or the trainings. This is even more obvious, I guess, in the case of developing new IT systems, because the agile approach came from the IT project development. So you would, instead of coming up with a new IT system straight away, based on initial specs, you would iteratively look at it. Does that meet the requirements as per the intent of the legislation? And then you go through particular functionalities after functionalities, and then you develop it along the way instead of having the whole system developed as a package. And to wrap up, I would just say that both aspects are quite critical and complementary. You've got the outcome framing, as Anna mentioned. It's about making sure you're achieving those outcomes, and this is what will lead you in terms of adapting, pivoting to, but keeping in mind those outcomes. This is the end game. And you've got this iterative assessment to make sure you're on the right track along the journey and you have the ability to change course without having to wait for 2 years. And in a nutshell, and as the OECD pointed out in its regulatory policy outlook in 2021, I would just say evaluate, don't just regulate.
Thanks, Florent, spoken as a true evaluator about the importance of evaluation. So we do have a question that points to probably one of the big elephants in the room, which is, what happens if your legislation is not very agile and you're trying to work within it? I might pose this question to each of the panel members in a slightly different way, and maybe start with you, Anna. The ACCC had the luxury of the authorisation process, which meant you did have a discretion. I was just wondering what you think might have happened if people were proposing to do things and you didn't have the discretion to authorise it. How would the ACCC have dealt with something that was going to be illegal and you thought it was going to be helpful for solving the COVID problem, but you didn't have that discretion? Would you have been willing to be so agile as to overlook a non-compliance, if that's what the legislation was leaving you to do.
Yeah, I'm not sure about that. I just think it's very lucky that, well, in the first instance, we have this authorization test, and the actual test itself is a net public benefit test, and so it works really well for this sort of this approach. But having the interim authorization was like a superpower, to be honest. And so I think that we were really lucky that we had it, because we didn't need to face a question like, do we just not enforce? But to answer the question in another way as well, I learned very early in my career not to say, can we do this, particularly to a lawyer, but to say, how can we do this? So my personal approach would have been to kind of figure out what it is that we really needed to achieve, and then to try to figure out how we can get either there or in that direction. So I always think that asking the question, can I, is not the right question.
Yeah. Miguel, you mentioned in your talk about the need to make sure that it's not just the design of the regulation that's agile, but also the delivery of it. I guess if people are dealing with regulation that hasn't been designed well, or isn't, given much opportunity to be agile, do you think there's some ways in which the people who are responsible for the delivery of it, consistent with what Anna said, can use agile? They can be agile regardless of the fact that they might have a quite restricted, overarching piece of legislation that they're dealing with. And what are your thoughts about how best to do some of that?
Yeah, well, two things. One is, indeed, the recommendation is really on the better regulation side of things. So the idea is really to help when governments start thinking about, what could be the right regulatory frameworks in the face of innovation, to precisely rethink the regulatory frameworks, and to avoid, having a situation where specific regulatory agency or specific regulatory institutional setup basically prevent the proper management of the challenges raised by innovation. So that's really about this. That said, I do feel that there is a couple of low-hanging fruit there. One being, reinforcing the coordination between government agencies, tapping on the expertise of the different government agencies across the country. So that's one thing. Same for, international regulatory cooperation. International regulatory cooperation is not necessarily about, developing a joint approach to regulation, but this is also trying to foster, peer learning, mutual learning. It's quite unlikely to be the only country facing a problem with blockchain. So, you might want to tap on other expertise in other countries. So that's another way also to be agile. As regards RIA, and as said by Florent, the idea is really to be much more iterative, flexible, and adaptive as regard, the way you develop regulations. And I do feel like there might be also a need to think, to accept, for example, less extended regulatory impact assessments, on the understanding that you might want to refine the exercise as soon as you get new evidence on the problems, rather than spending, weeks, months developing the RIA, and after that, being stuck in kind of regulate and forget approaches. So really moving toward this kind of pilot and learn approaches to regulation is really the key idea behind. And I completely agree that in some cases it might need some form of regulatory change, basically.
Yeah. So practitioners can really sort of try and influence the way governments look at how more should be defined. And I think, the ACCC's authorization power is a great example of an agile piece of legislation. So there's we should look out for some more like that as well. Florent, from your point of view, have you seen people managing to think about the how, even if they're faced with some legislation that's not particularly well suited to an agile environment?
I think there may be something relating to regulatory, the staff, giving license to staff that and training them and the capability to think beyond the legislation, because sometimes you may think that's it, that's your boundaries, and you cannot think, and so getting them to think in terms of outcomes, and that's the regulation is one tool amongst others, and so yeah, equipping staff, training them, giving them license to it is possible to change things, to tweak things, and also to collaborate with your regulated entities. I think sometimes staff within regulatory agencies may be limited by some traditional ways of doing things and some artificial boundaries, I think.
Yeah. And one of the questions that has just popped in suggests, another way of doing things might be to share some of the regulatory burden with people who aren't the regulators. So I think there's lots of opportunity. Miguel, I was going to ask you, a lot of what I've seen from the sort of world of Agile in IT land talks a lot about the culture of the teams, and a lot of emphasis is placed on having the right Agile culture. And I know we did a lot of training of teams to make sure they all have the same culture. How do you think that might play out in regulating in an Agile way? How important is it that everyone gets it and can be Agile?
Well, we've done basically a study recently, it's going to be published quite soon, on the regulatory delivery side, on what are the key barriers to, trying to modernize a little bit enforcement, and really on a set of different case studies across countries. And basically one of the key barriers is the organizational culture, basically. So, because, well, if there is a regulator that is risk adverse, might not be willing to move towards more agile, way of doing things, relying on digital technologies, being more risk-based, more outcome focused, basically because it might create a sense of insecurity, for regulators. So, and if you have this kind of regulatory organizational culture, basically there is no incentive to move into this direction we're trying to put forward in the recommendation. And that might even be a public perception, for example, that physical inspections might need to be done, and you can't do that remotely, basically. So there is a lot to do in that area without necessarily changing the regulatory frameworks, with of course a lot of legal, technical, institutional barriers. But I mean, the culture of the organization is absolutely key also to move towards more agile ways to enforce regulation in that space.
Anna, how did you deal with the sort of issue that people who'd been doing authorizations maybe in the past hadn't done it in this quick and dirty maybe way? Was there a sort of culture issue about getting the staff and the commissioners on board about being comfortable and a bit willing to take the risk of doing it this way?
Look, I have to say, so a lot of this happened before I actually started, but it has continued since I've started. But I think, it wasn't a hard ask really, because the staff really do work towards the purpose, and they could see a massive purpose, and that they were really doing a great job. And I think the commissioners really threw themselves into that as well. And one of the things about the way that the ACCC runs its meetings is that they are on Teams, and all the staff who have worked on it can actually watch the meeting going on, and they can see the level of engagement of the commissioners and have debates with the commissioners. And so that cultural aspect and the ownership, and also making decisions and having them out and having them implemented and seeing a result. So culturally, it was actually probably quite easy to do. Perhaps the harder part culturally through COVID was deprioritizing some other work. So, swinging those resources, and you don't want to tell people that what they're working on is being deprioritized. So potentially, but But where there's a really strong purpose and people understand that their work means something, I actually think, that they dedicate themselves to it.
Florent, I just wanted to ask you about, having an outcome focus, and you gave the example of some outcomes there. Often very hard for people to feel that the outcome's been achieved. The measurement issue is difficult, so people tend to sort of fall back on measuring their level of activity rather than whether they're achieving outcomes. What's your thoughts about just, getting the people who are doing the work in the regulators to appreciate that they've achieved these outcomes and telling them that story?
Yeah, so I think that's very important for them to be part, if possible, in designing this story, sort of, co-designing. So what's the end game and how we're going to get there, and we're doing some compliance work, communication work, enforcement work with, and that's not the end game. It's not compliance for the sake of it. It's for a particular purpose. So getting them on board with this sort of storytelling type of approach. Feedback loop is also very important to see the difference that they're making. It's true that we tend to fall back pretty easily into measuring the stuff we do, the number of inspections, the number of fines. I think this is the role at a high level to link those different dots and tell the stories, not only based on hard data, but also based on what's coming up from the ground, because quite often it's also qualitative stories. And the ultimate sort of outcome, the end outcomes, yeah, they can be tricky because they're also influenced by so many factors, external factors, the economy, new players, overseas online players that you may or not, have any control over. But the end game is more around, people trust the businesses they're dealing with or something like that. It's not just compliance. But I think to get staff engaged is about the whole story and a step by step, and then telling this, it's a contribution story and not attribution. We're not going to solve all the problems. It's a big piece. You're part of that.
Great, thanks. We're coming very near to the end of our time, so we'll have to finish up there. I'd really love to thank Miguel, Anna, and Florent. As I mentioned earlier, the OECD recommendations are on the OECD website, and they're really worth a read. I think Agile Regulation is going to be a thing going forward. Certainly, COVID has taught us that if new technology and innovation hadn't already started to do that. As I mentioned at the beginning, this will appear on the website, the YouTube channel shortly. And I'd just like to mention next week, we've got our next event. Very excited to launch the South Australian chapter of the Community of Practice. We're going to do this as a hybrid event. There'll be people in the room in Adelaide, but also people will be able to watch online. And very excited that we've got Kate Jenkins, the Sex Discrimination Commissioner, talking about her recent reports and the role of regulation in some of the issues she's been looking at. And Sarah Court, who's a very long time Adelaide resident and well-known regulator from both the ACCC and now at ASIC. And I'm very excited that we've got Sarah talking about what it's like to be a regulator from South Australia, and the great work that she's done as well. So I really encourage everyone to join us there. Any questions that we didn't get to in detail, the panel members have very kindly offered to follow up. And so we'll be doing that. And we look forward to talking to you all again soon.